Good afternoon, everyone. Today is, June 9th. Where did I get that from?
17th.
Okay, today is Friday, June 17th, 2022. The time is 1:30 p.m. Thank you. We are meeting for for deliberations, and attending our commissioners, Duncan and Filios. Commissioner Bill Brooks is excused, by the way. He had some very serious oral surgery. And so before we go any further, why don't I ask Vlad to lead us, please, in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Okay, do we have any conflicts of interest? Hearing none. Okay, so I don't have any opening remarks necessarily, but I'll defer to Director Callahan and our attorney, Pat Braden. Gentlemen, would either of you like to say something before we proceed?
Pat Braden, Civil Deputy Prosecuting Attorney. I just wanted to address the issue of a potential tie vote, since there are only two of you here. A tie vote would be tantamount to it would cause the motion on the table to fail. And if it was on the ultimate question as to whether reconsideration, what should be, whether reconsideration is appropriate or what should be done to reconsider the original decision, if there were a tie vote on a motion on that ultimate issue, then that motion would fail and we would revert to the original decision.
So revert to the original decision.
Yeah,
Okay.
which was of approval.
Okay. Anything else, Pat?
No.
David?
Just that was April 14th signing that you conducted, in which you and Commissioner Filios and me and Commissioner Duncan voted together.
Okay.
And as I recall, you finished the public hearing at your last meeting on the 9th, so now you're in deliberations, which you customarily do amongst yourselves and only ask staff if there are factual questions.
And I actually just have one more question for Pat. Pat, on this specifically, because I have 67, 65, 35 in front of me.
Mm-hmm.
What the reconsideration was about we failed a procedural issue in the conclusion that we came to. Is that my understanding?
Well, it's been contended that the board made a procedural error in reconsidering and reversing its original vote. And so I'm bringing up the statute in question myself, so I could. Oh yeah, the statute, first of all, requires that approval or denial of an application be based on express standards and be in writing, which it was both. The decision has to be a reasoned statement that explains the criteria and standards considered relevant, states relevant contested facts relied upon, and explains the rationale for the decision based on the applicable provisions of the comp plan, relative ordinances, statutory provisions, etc. Failure to identify the nature of compliance or non-compliance with express approval standards, or failure to explain compliance or non-compliance with relevant decision criteria shall be grounds for invalidation of approved permit or site-specific authorization or the denial of same on appeal. So I don't believe the request for reconsideration has identified any compliance or non-compliance with express approval standards, nor did it fail to explain compliance or non-compliance with relevant decision criteria. The order of decision in question was our typical order of decision, which, as is typical, went into great detail in discussing the facts, providing the relevant facts, providing the applicable law, and doing an analysis of how the facts are properly to be applied to the law, or vice versa, I guess you could say. Either way, I believe the ultimate decision, particularly the ultimate written decision, complied in all aspects with those requirements. And I don't believe the fact that the vote was reconsidered at the time of the hearing on this matter, nor the fact that, technically a member of the minority in the original decision made the motion to reconsider the vote as opposed to a member of the majority, especially given the fact a member of the majority seconded the motion, and the fact we do not strictly abide by Robert's Rules of Order, I don't believe was at all defective, particularly given the clarity of the subsequent written order.
Okay.
So,
And then.
kind of a long-winded answer to your question.
Yes, thank you. No, I appreciate it very much. So does state law require the Board of Commissioners to strictly adhere to Robert's Rules of Order?
No.
Thank you.
Okay. So Pat, in our deliberation, and that's a very good point, because I recall when ICRIMP, our insurer, who typically sponsors many of the meetings, especially as we go through orientation for new commissioners, they were very specific on that point, that the Board of County Commissioners is not bound by Robert's Rules of Order. Anyway, second question that I have for you is, in our deliberation, should we disregard the procedural and just deal with the substance of the arguments?
You're free to deal with either or both. That's completely the board's prerogative.
Okay. All right. You okay?
Yeah.
Okay then, and I guess I should have announced this right up front. So the deliberations obviously are dealing with PUD, that's PUD 21-0003, Gosser Ranch Golf and Lake Club, a planned unit development, and it's a final discussion for approval of an amendment to the existing PUD. Okay, Leslie, do you want to share some of your thoughts?
Sure. So I think that the reconsideration or the appeal should be denied, and I think the original should be upheld because, once again, they are voluntarily, they meaning the applicant, not the appellant. The applicant is giving up their development rights. And so I think this is a good thing for the area in particular. I did not find that there was a procedural error. I did not find that in the testimony that we heard on June 9th that anything was proven to warrant the reconsideration. And as our attorney explained, going through how we came to the first decision, looking at facts and applying them to the law, I think was completely appropriate, and so I would move to uphold the original decision and I guess deny the appeal.
Okay. Okay, my turn. And so as I look at this, and ignoring the procedural, which I'm going to do based on our attorney's opinion, and I look at the different aspects with regard to the substance of the case. When you get into the question of wildlife, I don't think there's any real discussion there one way or the other in terms of disturbance of wildlife corridors. It may be possible, but we don't have any expert opinion that indicates that that's an issue. Regarding the various other districts that have opined, nobody seemed to have any serious objections. I did hear concerns, and it was very challenging for me because I know many of the folks who live on that side of the lake, Some certainly I would consider friends, which makes it even more challenging. But when I hear comments, for example, regarding the size of the homes, hey, listen, if you can build a 10,000 square foot home, knock yourself out. That is your privilege, and it's not for me to opine on that matter. And from that perspective, if we get into the question of the water that's being drawn from the lake, these homes are 80% of the time unoccupied, and they're typically not VRBOs. So the strain on the resources, and especially the water resources, is probably fairly minimal, and especially compared to the contribution to the tax base. As far as the road is concerned, now that's probably the most serious of the concerns. But if I were to oppose this on that basis, I would have to oppose every petition for every home that's going to add any traffic, specifically construction traffic, to the road, which is a problem. And it's especially a problem around Beauty Bay, because obviously for some of the stretch, you have a 2.7 mile of reconstructed road, which is Burma. But the problem really occurs as that traffic converges over the Beauty Bay area. But to take that position and deny Gaza, I'd have to deny everything else and every other petition that comes before us. And so, as difficult as it is for me, and as I've said before, we probably never should have permitted wide-scale development on that side of the lake, but it's done. And again, what are we doing? We're not adding to the density. We're maintaining, basically, we're taking in 28 acres for a rec and a medical facility. So in terms of the additional load and any issues that are going to be, how do I put it, that are going to be aggravated, I don't see that that's any more of an issue than any other petition that might come before us in this case. So I have to agree with Leslie. I would have to agree that to uphold the original decision in favor of the applicant.
So I move that we uphold the original decision for PUD 21-0003 Gaza Ranch Golf and Lake Club Planned Unit Development, thereby denying the appeal or rejecting the reconsideration.
Second.
Bill Brooks is excused. Commissioner Duckman?
Aye.
Chairman Philios?
Aye. And the motion is carried. So PUD 21-0003, the original decision to uphold the applicant's request is hereby approved. Time is 1:43, meeting adjourned. Thank you.